A question I am frequently asked in the bankruptcy or divorce context is, am I liable for my spouse's debts? And the general rule in Virginia is no. You are not ordinarily liable for your spouse's contract or tort liabilities simply by virtue of the fact that you are married. There are two exceptions to this general rule, however, and the first one is based on the common law doctrine of necessaries, which at common law, under case law, a husband or father was responsible for the support and sustenance of his wife and his children. Now, by statute in Virginia, Virginia has expanded the common law doctrine of necessaries to apply equally to both spouses. So in Virginia, both spouses are liable to third parties for his or her spouse's necessaries, which might be food, clothing, necessary medical care, shelter. And what's necessary for one person may not be necessary for another. So necessaries at law has some relationship also to the person's standard of living, what they've become accustomed to. This liability for necessaries is not enforceable between the spouses. Each spouse may have an obligation to support the other, but the doctrine of necessaries itself applies to being liable for your spouse's debts to some third party. The doctrine of necessaries does not give a third party creditor the right to attach the interest that the spouses or the surviving spouse has in a tenancy by the entirety in Virginia, which is a tenancy that we have here based on the legal fiction that a husband and wife are one. And it's a special kind of tenancy not only because it offers a survivorship where the surviving spouse becomes vested with the entire property upon the death of his or her spouse, but it's also protected from the creditors of either spouse alone. Only a joint creditor and a supercreditor like the IRS can acquire a lien in property that a husband and wife own as tenants by the entirety. Now, the second exception to the general rule that you're not liable for your spouse's contract or tort liabilities is the liability to a physician or a hospital for emergency medical care, and during that admission, the necessary inpatient care along with that. This liability would run to the physician or the hospital and would only cover a true emergency, which is a health condition that if it were not treated would impair the life of the person or result in a serious medical condition. The third point I'd like to make, and this is not an exception to the fact that a spouse is not liable, but we often unfortunately see situations where one spouse believes because he or she is married that they have the right to sign documents for their spouse. And there is no such legal right in Virginia. A spouse does not have the legal right to sign documents on behalf of his or her spouse without a validly executed power of attorney, just like anybody else. I encourage you to speak with your own attorney